So, a question I get a lot as a HR consultant is how much should I pay in severance? Well, we're going to get an answer to that question today for Americans. I'll do a Canadian episode another time. That whole discussion is coming up now. Hi there, I'm Andrea Adams. This is the HR Hub, and on the show, we talk about anything related to HR. I encourage you to subscribe to the show or to the podcast to keep learning from my amazing guests. So today my guest is again Leah Stiegler. Leah is a management side employment lawyer from the Virginia area. She's a partner with Woods Rogers, and she has a YouTube series for HR and leaders called What's the T in L&E? Hi Leah, how are you?
Hi, thank you so much for having me.
Well, thanks for coming back. That episode we did on workplace romances was so funny. I think it's going to be a popular one because, yeah, we all want to know. But we're going to talk about severance, which is slightly more boring, but certainly useful. So I'm Canadian, so I'm coming with a Canadian perspective. I'm going to try and stick to questions relevant to Americans or anyone operating in the States. So let's clear up this first question. Are there laws in the US, either state or federal, governing severance, or is this entirely just a business decision?
Generally, it's just a business decision. And
Really?
I would say severance isn't so boring, Andrea, because you're dealing with money and terminations. Okay, that doesn't get there's nothing more exciting and wild than someone losing their job and their identity and their money, right? And then now we're talking about a package to help them transition. Um,
Yeah, that's right. Like when you're doing a termination, emotions are running high for, the moral obligation, plus the cost of doing it, plus the, sometimes interest in doing the right thing. Or often what I see with employers is they're so mad at the employee that they want to give them as little as possible. So yes, emotions are often running high. It's curious that there are no laws because in Canada, there are certainly laws. I said I wouldn't talk about Canada too much. When HR is calculating severance packages in the US, then what's the standard formula? And if you're going to terminate in the US, should you be talking to a lawyer?
I'm going to give you well, you should always talk to your lawyer, of course, and that's not a plug for us lawyers, but that really is is protection for a company in the sense that, an ounce of prevention is worth a pound of cure. You want to make sure that you're assessing risks. And this goes in part with answering the first question, which is what's the formula? The annoying answer to that is it depends. There is no set formula. I'd say, historically, if it's something like a reduction in force and you're laying off a significant part of the workforce and you're trying to come up with a fair way for everyone to depart, and you don't want to have, Joe getting 7 weeks and Sammy getting 3 weeks and just some arbitrary decision making, companies usually do implement a formula, and it could be everything from everyone gets a minimum of 4 weeks plus another week for every year that you've been with the company, something like that, right? So that would be a common formula for something where you've got a number of employees and it's sort of a form termination. When you're looking at a one-off termination, let's say a performance issue, and this morning I actually had 2 calls dealing with severance conversations this morning. One of them was a senior leader who was pretty high up in the C-suite, and the first thing I ask is, do they have an employment contract? Because while we don't have laws in the US that say you are required to pay a certain amount of severance, if you've executed an employment contract with an employee and that contract provides for severance in certain circumstances, like if you're terminating them without cause versus with cause, many times a contract will say they'll get 3 months or 6 months of severance, something like that. So we always ask about that. Then we're also talking through the risk. So what risks do we have in terms of them potentially suing us, and how much are we willing to stomach to hand over to get them to release their right to sue us in order to part ways from a nice amicable transition standpoint.
Hmm. We do have releases in Canada as well for the same reasons because we don't want to get sued.
Do you guys have to, if your law says you have to give 2 weeks or something, does it also say you can't give a release for that baseline of the law, or do you have to give more than what the law says to get the release?
Yeah, so in employment standards, there is a minimum, and you have to pay and it's based on years of service. So if you have, who knows, some amount of service, there's amount of severance you must pay if you lay that person off without cause. With cause is zero. Um, so yes, we do have laws like that, but typically, case law, we have to pay a whole lot more related to age, related to employability, related, and again, the employment contract matters a lot. Is there an employment contract that limits the amount of payout?
Sure.
That's all relevant too. So, can you walk me through, because it sounds to me like sometimes with cause you will even pay severance. So can you walk me through the difference between a severance in a layoff case where it's without cause and a termination for cause? The rules change a lot in Canada, although we may just opt to say, I don't want to deal with litigation. I'm going to act like it's without cause, even though it was with cause. Um, what's it like in the States?
Yeah, that's a really great question. So generally, I mean, the majority of employees in the United States are employed at will, meaning either party can terminate the employment relationship at any time with or without cause or with or without advance notice. Uh, that said, even if you terminate someone for whatever reason, they can still sue you if they believe their termination was for an unlawful reason. Let's say their age, a disability, retaliation for, reporting harassment or being a whistleblower, whatever it may be. So the way I work it out with companies is I really dig deep into why are they letting this person go. So
Mm.
I'll give you, just talking this morning with that example in the C-suite situation. um, we were looking at performance issues, right? The person wasn't managing subordinates appropriately. The person wasn't carrying out project initiatives, not meeting deadlines, letting things lapse over time, whether they were sort of, bills that the company was supposed to pay and whatnot. And that puts a significant amount of liability on the company. So we say, okay, we've got great reasons for terminating. So if this person turned around and tried to sue us, we have a really strong defense. But at the same time, the individual was in their 70s. And so that would limit their ability. They might look from an optics standpoint. The rest of the senior leadership team was 50 years old or so, or younger. These are all questions I'm going to be asking the company. From an optics standpoint, that doesn't look very good, right? A plaintiff's lawyer might say, hey, this is an attractive plaintiff, right? I'm going to play the age card on this one. So you've got that risk. We also look at, from a practical standpoint, what sort of other legal risk standpoints do we want to impose, such as a non-disparagement? This could be a messy termination. This person might be well connected. Earlier this morning, I was on the phone with a company, a nonprofit, and they had an employee who was a fundraising employee who had a great relationship with all sorts of donors and
Mm.
people in the community. And while they had really good cause to terminate them because the individual engaged in misconduct, they um we decided, let's go with some sort of severance, because this person, we want to make sure we have a non-disparagement signed with this person so they don't go badmouth us, because
Right.
that could hurt our business, right? So it turns into a business decision. It's not always like an admission of liability.
Right. With non-disparagement though, I mean, how do you ever enforce that? You don't know what someone's saying in, some coffee chat. Yeah, my, this organization, they're run by a bunch of losers, and guess what they did? And oh my God, and then they share information about how much they were paid and et cetera, et cetera. How do you ever enforce that? Like that is a very common problem here.
Well, I think it would be really hard to police the coffee chats, but boy, it is not hard to police the social media posts, because I will say, in today's world, we see so many terminated employees go online, badmouth the company. They'll leave nasty Yelp reviews on or Google reviews. They'll post all sorts of false things on Indeed or on the company's social media pages on LinkedIn. So those ones are easy ones where we screenshot it, put it in the books, and we say, hey, you violated the non-disparagement provision. We're going to stop severance payment, or we're going to bring an action against you. So yeah, I think that I also would say they often reach out to employees who are still employed, because when someone gets terminated, I think we have to consider the fact that that's going to harm their reputation and their identity. And those coworkers who they normally walk in every Monday through Friday and say hello to, those coworkers are going to be wondering, well, why is Jerry not here anymore, right? And so they're going to be saying, hey, texting the person, hey, man, what happened? And that person's going to be able to paint the picture that they want for those employees. And this is something an employer needs to consider, is what message do we send out to our employees that are still here if
Hmm.
this former employee reaches out to them?
Hmm. Okay, asking that question, what are you allowed to say? What is it like? What is the employer allowed to say to somebody that's, and what's advisable about somebody who's been let go so that the employer's side of the story ever gets any air?
Yeah, yeah. That's a great question. I think it's going to be case specific. So, if you execute a severance agreement that has what's called a mutual non-disparagement, where both the company and the employee agree not to disparage each other, then and the company, we usually define that in the severance agreement as the company, for purposes of this provision, is the senior leadership team and the HR team, because you're not going to police what your lowest level employees are really saying out there.
Yeah.
So you definitely would want to be very careful with your message. Work with a lawyer in terms of crafting to the rest of the employees what that message is, because if you go and say something, you could be in violation of that mutual non-disparagement provision. The other part of it is a practical concern. So usually I'm recommending, the employees who work kind of with this person, but not that often, you're going to send out more of a, just to letting you know that this person is no longer with the organization. We wish them well in their next, endeavors. If you need anything that you used to obtain through this employee, please go to their supervisor, blah, blah, blah. But then I often recommend make sure that, the lead supervisor of a department where that's really impacted by the termination, and maybe an HR professional, go and have one-on-one conversations with those coworkers. And depending on how much information you can disclose or what would be appropriate, we usually give them talking points and kind of walk them through, because you as the company, you want to establish that, this wasn't an unfair or wrongful termination, especially if that former employee is still in communication with their coworkers.
It's so sensitive about how you do that without, it's just not pleasant to badmouth people who have left and who are going to be having rough times because they're no longer employed.
Sure.
And yet, um, communicating that this was about our organizational values or misalignment there, and we really believe in this. And, that's some careful communication crafting there.
Well,
Uh,
you also have to be concerned about facing a defamation action as a company, because in
yes.
in the U.S. And in most states, it's more of a state specific thing. Um, an actual company is defined as an individual who can face a defamation claim. So if a senior leader, and we've had situations where an employee is terminated because we believe they've misappropriated funds, and some senior leader goes around and starts talking in the community, whether it's to their spouse, who's then telling her book club, who's telling whoever, oh, blah blah blah, embezzled, did you hear they embezzled, right? Because gossip is good, right? And so, the company can then face a defamation action if they were defaming somebody, with false
Mhm.
information. And so you really want to educate senior leaders from an HR standpoint, educate those leaders as to, what they should and shouldn't be saying, and why that not only protects them, but it also protects the company.
So, when you and I met before this, you said that most employees in the United States don't have employment contracts. I'd say the reverse is true here. But how does that affect what they're entitled to when they're let go?
Yeah, it impacts it, because the employment agreement is going to, if it discusses severance, it's going to give you a baseline. So,
Mm.
and really, the reason you want to give someone a severance, and I hope I emphasized this earlier, but it's when a company is giving a severance to someone, they're giving them a lump of money that they're not generally entitled to, and this is in the U.S., in exchange for them releasing their right to sue you. So I think companies sometimes go wrong. I had a client a couple weeks ago. They called me when they received a demand letter for an employee and they said, yeah, but we gave her 3 months of severance. I said, well, did you make her sign a severance agreement, which is an actual contract that says we give you this and you release your right to sue us? And they said, well, no, we just gave her the severance. And I'm like, well, no, you just gave her a wonderful benefit, but she can still sue you. She didn't release any right to sue you. So a severance is actually giving someone something they're not entitled to. And you want to make sure you execute an appropriate agreement when you're doing that. The employment agreement sets the stage up front for what a base severance departure package is. And that usually will say what someone is legally they're entitled to by way of that employment contract. So if you terminate them and the employment agreement says that if you terminate them without cause, and the agreement is going to define what cause is, let's say in misconduct, severe neglect of duties, whatever, criminal activity, whatever it may be, that you've got to give them, let's say, 6 months of severance. And so that's 6 months they're already entitled to. And if you don't give it to them, then they can sue you for breach of that employment agreement. So I always tell companies, you're already giving them this, you're already required to give them this 6 months. Now we may need to consider an additional amount on top of that if you want to get a release of their right to sue you, or you want to get some sort of non-disparagement or additional, non-compete protections added in here. So that's where you're going to assess the risk of them bringing some sort of claim and assess sort of the other operational needs, like for the non-disparagement and whatnot. On top of what's already required in the employment agreement.
That was like super informative. There was a lot in that. What do you see? You referred to that situation where they gave severance without getting the release attached to it. What are some other big mistakes you see HR teams making when it comes to severance?
Using Google to find a severance agreement. That happens way too often. And they're finding some sort of severance contract online, which has totally inappropriate or unlawful language in it. I love ChatGPT. ChatGPT is the smartest employee we have here at the firm, probably. But I will tell you, you do not want to just rely on ChatGPT in writing your severance. And so I have seen some really hilarious severance agreements that don't actually protect the company, right? In any way, or they might be very employee friendly. And so I will say a big mistake is companies not actually working with legal counsel. And I can tell you, every single employment lawyer that you work with has template severance agreements. They're going to talk you through the termination, and they're going to help you execute that severance agreement. And it won't be more than an hour and a half usually of their time on average.
Which in the end, in avoiding, the cost of being sued and the litigation costs, it's money well spent.
Yes, absolutely.
Just happens way too often.
Do it right up.
As I said earlier, in Canada, things like age and position level, employability at a future job, years of service, that all impacts how much severance will be. Is that relevant in the States, or is it just like how much you can pay them so they'll sign the release?
No, that is definitely very much relevant. It's not like that's part of any sort of particular formula that an employer is required to consider, but it's relevant because you as a company are trying to assess your risk of having to fight litigation by terminating this person. And so so I'll give you a simple example where, a company a client of ours, they wanted to terminate somebody who was a pretty senior level person. And the person very recent, only a few months before the termination, had reported what they characterized as harassment from their coworkers. Basically, their coworker, they claim that their coworkers were making inappropriate comments about their religion, and pushing them on certain things, about Islam and whatnot. And so the company had just done this whole investigation, but parallel to that, the person had performance issues, according to the company. And so they wanted to let this person go. And they're asking me, well, what are our risks? What are our risks? And do we have to give a severance? And I was like, well, you're saying that you want to terminate them for performance reasons. So show me your performance documentation. I want to see what my exhibits would look like in court in front of a jury if this person sues you for retaliation. And they're like, well, they were mostly verbal conversations. Well, Now it's going to be you sitting on the witness stand and him sitting on the witness stand and him saying, I was a fantastic performer. And you saying, yeah, no, this person, well, we had multiple conversations, and the jury's just going to decide who's more credible. And to get to court, you're probably going to spend 200 grand in legal fees. So I said, you really don't have a strong defense if you don't have good documentation. And so, that's a significant risk there, because there's one perception here, that is, this is retaliation. It's close in time to him reporting harassment, to, the fact that you don't have any real good documentation to support that he's had these other performance issues, versus just someone verbally saying to him, that he's not performing.
Okay, we have reached the end of this. Where can someone learn more about paying severance in the States? I guess actually, before I get there, one question. How much variance is there state to state?
That is a really good question. I'm actually not aware of any states in the United States that require you to pay severance to your employees. So, it's really going to be very similar to what we just discussed, in the sense that a company is going to have to, on a case by case basis, assess the risks and assess from a business standpoint, how much severance they can really stomach and what they want in return for that, whether it's someone departing quietly, whether it's a non-disparagement, or non-compete, or whatever it may be. So yeah, no, I think it's very similar across the board.
Okay, now, where can someone find out about what they should pay in severance? And where can someone find you?
Well, you can find me on LinkedIn, Leah Stiegler, LeahStiegler. My firm, we have a wonderful labor and employment team. So you can go to woodsrogers.com and you can sign up for our e-alerts. And we issue very, very regular e-alerts on various HR and employment related topics. And then you should follow my YouTube series, What's the T in L&E? That's labor and employment. And we do various HR topics and employment law topics every 2 weeks on short 2 to 4 minute videos. And we definitely talk about things like severance and dirty terminations.
Right. Okay. All right. Well, let's leave it there. Well, thanks, Leah. I love that. That was fun as well. I'm thinking about both differences and the similarities. Like, we talk about use much of the same language in Canada, but there are still quite a number of differences. Leah and I did a super fun episode on workplace romances, and the link to that is right here. Thanks for watching out there, and see you next time.